today we are here to talk about the North Carolina forms changes that took effect on July 1st. And the reason why we waited a little while were two reasons. One, because North Carolina realtors didn't publish the forms until right before they were happening, and it was right around 4th of July, and a lot of people were out. And two, we wanted everyone to kind of see what it was, because you don't have to use them for 60 days and be able to have some great questions in today's session. I'm not going to hit every single form that was changed, but I'm going to hit the basics of everything. We don't necessarily have to look at the new construction, the vacant land, if we're looking at the offer to purchase or the exclusive buyer agency or the exclusive right to sell. So I'm going to hit the main ones that we'll use. If you have specific questions about a form I'm not covering, reach out to me personally and we can talk through that. I just want to make sure we use everyone's time to the best advantage on the forms that are used day in and day out. And then at the very end, if we have time, I found an advertising quiz that I thought would be something good for us to run through and we could get your feedback on. So I definitely want participation. I definitely want questions in the chat. And so Haley, if you will tell me as I get through each one, if there are questions in the chat that you want me to answer, because I'm not going to have the chat pulled up as I'm walking through this. So just to give you an overview of what we are going to cover, we are going to hit the offer to purchase, the buyer possession before closing agreement, the seller possession before closing or after closing agreement, the agreement to amend, the exclusive right to sell listing agreement, the exclusive buyer agency agreement, the notices that sellers exercising their right to terminate, and the referral agreement. That's what I've got on tap for today. And then we can go deeper on anything that you want, but I thought I would pull that up first. So as we get started, let's pop over to our exclusive right to sell listing agreement. So these are all going to have highlighted changes on them. These are things that you all can get at the ncrealtor.org location as well, or I'm happy to share. I have a whole folder of them. If you'd like access to my drive, just let me know. It's on Google Drive. So in North Carolina, what they wanted to do was make things more concise and very easy to find things and locations and to bring things up. So fuel tanks was moved to its own section. And so it was taken out of the specific items that are to remain with the property. And when they were doing that, it's because fuel tanks can be leased or not leased. And we want to make sure we're very clear on that up front. And fuel tanks has been a topic, whether they're buried or not as well. So we're going to touch on that. But you'll note here, we'll talk about fuel tanks in a minute, that they just clarified swimming pools. They just wanted to make sure everyone realized that inflatable pools, spas, hot tubs are not included in the purchase of the property. But of course, if they're on the property, hot tubs were added a few years ago, and that is still there. They just made that drapery piece a little clearer to say curtain and drapery rods and brackets, because as we all know, curtains are personal property and they do not give. So that was just basically a cleanup by the Forms Committee. And by the way, if anyone is interested in being on the North Carolina Forms Committee or any other North Carolina Realtor Association committee, the deadline is August 31st, and you can easily sign up in 2 to 3 minutes if you go to northcarolinarealtors.org, or if you want me to give you a link, I'm happy to do that. But the more of us that get on committees like forms committees, the better it is for us to make changes and see things that we want to have happen. So if you see something that you don't like here, you think we need to be looking at it for the next forms piece, please raise your hand and share that information as well, or put it in the chat or reach out to me personally. So it basically here again is removing fuel tanks out of this section because they've added their own section. And again, this is the exclusive right to sell listing agreement. They've done very similar things in each of the forms, so you might see this as repetitive. It removes attorney fees and costs. And again, this is just to clear up and make room for it down at the bottom of the document. So I'm just going to move down to where all the action is. So here, the fuel tank. Again, we've always had this fuel tank 1, fuel tank 2. If you sell in the middle of Charlotte, most of the time you're not going to have a fuel tank. But if you're anywhere on the outskirts, you will. And the one thing I will say is if you're selling in the middle of Charlotte and you're selling in older neighborhoods, be very careful to make sure that you know whether there was a fuel tank that was buried and how that was handled. And if you're not sure, either double check or make sure that the seller is representing that properly on the form. We've seen a number of issues regarding buried fuel tanks with E&O with our errors and emissions insurance that I've had to deal with recently. So please be cognizant of that as you're selling property. So here it talks about whether you have tanks and whether they're buried or not, and whether they're in use currently or not. So if you have a buried tank, this needs to be addressed. So as we're looking at it, there are two things. One, you need to remember that the fuel that is in the tank, the seller cannot remove that fuel prior to closing, and whatever is there is no longer prorated. And it hasn't been for a couple of years, but I just want to remind you, if there's fuel in the tank, whatever's there at the end of the deal at closing, the seller is transferring that to the buyer at no additional cost. So if you have a seller who's very particular about they just filled up that tank and it's going to last someone 2 years, they need to consider that and negotiate it as part of the price, the purchase price of the home. Then they also need to be very clear as to who owns this fuel tank, and if it's leased, what the agreement is. And so this is basically just outlining that so that everyone is very clear. And it also reminds everyone that it is, I believe, a federal offense to tamper with any tanks on the property if it's not your tank or if it's not a licensed professional doing it. So please be cognizant of that. Home inspections. The checkbox for seller acknowledges receipt of Q&A on home inspections is gone from here. It is something you certainly should continue to provide to your client, but they moved this. Now here, pretty big change right here. So this is designated dual agency, and exclusive representation. As we all know, there used to be 3 boxes and it used to say dual agency. Then it said the exclusive representation, and then it had the designated. And they thought that was confusing to the client. And so what they did was put all of the dual agency and the designated in one section and the exclusive representation separate, so that exclusive representation is not between dual and designated agency. So here, as we're looking at this, this is important for you to know. Dual agency, seller authorizes a firm to act as a dual agent representing both the seller and the buyer, subject to the terms and conditions set forth in 17. So you need initials here. If dual agency is something your client is open to, initials need to go there. Then it says seller does or does not authorize the same individual agent to represent both the seller and the buyer in a transaction. So if it says does, then that is something that you mark. So if they allow you to represent both sides, which again changes the seller's rights and what you are going to provide them, because you cannot help negotiate, you're a facilitator at that point, that box needs to be checked. If they do not allow that, then does not needs to be checked. But then designated also needs to be marked. And if designated is initialed here, that means that if dual agency comes into play, even if it's 2 agents within our firm and it's dual agency, you've got to get both the buyer and seller's permission to perform dual agency. If you are not doing designated agency, if there's some reason why, and sometimes on a team, and if you are a team owner, team leader, or an agent on a team, one of the things that we need to make sure of is that your team has provisions as to how dual agency is handled, because there are several pieces from the North Carolina Realtors Legal Counsel that says if you're on a team, you might have to practice dual agency if you do not have separation of information and the motivations of a seller is known. So be very careful on this and make sure that you're filling it out properly. And if it ends up becoming a dual agency situation, even if there are 2 agents in our firm, we need written permission and everyone needs to be clear as to what dual agency is. And the biggest reason for this change is because the North Carolina Real Estate Commission was getting a lot of complaints regarding people not understanding what dual agency is or what designated dual agency is. And I'm going to clip over here real quick on here. Everybody, let's see, not that one. We'll talk about this one. So a lot of times the Real Estate Commission gets questions relative to how do you handle things. This is an old piece, but we all get these legal Q&As in our inboxes, and I encourage you to read them. One of the things that you should note is the North Carolina Real Estate Commission says that you must treat people equally. So if you're a dual agent and you've provided a CMA to your listing side, providing a CMA to your buyer side is something that you should do as well. So make sure that you're reading up and says when practicing dual agency, it is important to remember that an agent and his or her firm owe the same fiduciary duties to both parties, namely loyalty, obedience, skill, care and diligence, confidentiality, accounting and disclosure information. The agent and the firm must treat both parties fairly impartially, equally, and honestly, and must avoid conduct which would give either principal an advantage over the other. So if you're working and focusing on dual agency and have that come up, you need to be very clear, and you need to make sure that you're educating your clients on what dual agency means. And so again, if you're doing dual agency, you're initialing here. You're giving the seller the opportunity to check does or does not. And then since we do practice designated dual agency, they're initialing here. So if we are not doing designated dual agency and we're doing straight out dual agency, you will need another written consent, which is basically the seller authorizing you in writing and the buyer to act as a dual agent. And this again is going to be on the exclusive buyer agency as well. And it's one of the bigger changes for the July form updates. Terminations and breach. This is just clarifying and going back through the components of what you do. So it's basically acknowledging and understanding the agreement between two parties and the mediation, and then it adds in the attorney's fees here. And so it's basically merging mediation, attorney's fees, and how to handle termination. So it's taking what we've gotten and adding to it. They want to make sure that if there is a termination, they understand what a material breach is by the seller, and that the seller acknowledges that basically when they enter into the agreement, any way that they were to exit unless there's a unilateral termination reason is a breach of contract.
Hey, Tiffany.
Yes.
Nicole asks, when the dual agency is in writing, is there a separate form or?
There is not a separate form. Okay. You just need to get in writing that they understand that dual agency and they're agreeing to dual agency, not designated agency. And so that can be an email, but it needs to be in writing. So I would have a conversation, explain it, and then send an email. As per our discussion, this is what you're agreeing to. Please confirm back with me, and make sure all parties confirm back, not just one, but all parties.
And what if the buyer doesn't want representation?
If the buyer doesn't want representation, then that needs to be documented amongst parties as well.
Got it. Thank you.
Any other questions there?
Nope, that was it.
Okay. Let's see. Again, wire fraud, no changes to it, but just want to remind you guys all again to be very careful, be very diligent in making sure that you are educating and advising your clients. Just because there's a red line around this box doesn't mean they read it. So make sure you're clearly identifying this information. We are having a wire fraud piece coming up on September 7th, where we have the FBI coming in. So I suggest you all join us for that. And Haley will be sending out more details soon, but I just wanted to give a plug for that piece so that you get it on your calendars, because it's a not to be missed piece. And then again, here, it's basically, since they took away the Q&A and home inspections, they added it right here on a Q&A series. So it's telling you you can go to the North Carolina Real Estate Commission's website and pull all kinds of Q&A. So I would pay attention and make sure that you still provide those Q&As to your clients as part of your sample package when you do a listing, when you do a buyer agency, and when you have an offer to purchase. I think that's pretty important. Any questions on this listing agreement before we move on?
Nothing in the chat.
Okay. So just since the buyer's agency is very similar to that, we will pop through. So again, the attorney's fees moves to the bottom. Duties, they just realigned our duties and organized them a little bit differently, and our standard of care. And they just basically changed the headings here. So they again took out the Q&A on home inspection, but again, I would still share it. Just because they're not requiring it to be here doesn't mean we shouldn't share it. So I would share that. And there's also one other document that I found that I think would be advantageous for us to put into that sample package of stuff. And if you don't have a sample pack that you can just click a button and have it all go to your client at one time, or you bring with you on appointments, I would highly consider you put one together that has a copy of the type of documents they're going to sign, a copy of the sample, and always make sure it says sample on your documents or draft so that they're not using it because they're not authorized to use it. But having all of those sample documents of what you're doing is a nice way to package something to give to your clients, whether you're doing it digitally or in person. Again, designated dual agency on the buyer side. This is the same exact criteria as the listing side. No wording has changed here. It's exactly what we just went over. And they took this out: when dual agency arises, an individual agent shall not practice designated agency and shall remain a dual agent if the individual agent actually received confidential information concerning a seller client of the firm in connection with the transaction, or if designated agency is otherwise prohibited by law. So this is still rolled back up into the top, but I think it's important again to remember, if you know anything that is confidential or motivation on the other side, you cannot be a designated dual agent. You are going to be a dual agent. Now, you always have the ability, if your client is not satisfied with that, or one side is not satisfied with that, to designate someone in the firm that is not familiar with your client to handle the other side. So think about that and think about how you can handle it, because you want to make sure that you continue to practice real estate and continue to have an income. It's not just about that one deal and having both sides. It also can be about your real estate license. And we're seeing a number of issues pop up, so please be cognizant of that. Again, the termination piece is just rolling everything into one between the attorney's fees and mediation, so that it's not all over the contract. What they've been really trying to do is clean up our contract to get terms and provisions all under the right categories and together, as opposed to them being scattered all throughout the contract. And that goes for buyer agency, listing agency, as well as our offer to purchase. Any questions on the buyer agency?
Nothing in the chat. Do you mind zooming in a little more on the forms, please?
Sure, I will do it on my next form that I pop into.
Okay.
Okay, so I mentioned something about offer to purchase. Let's see. So this is a form. How many of you guys have seen this form before? How many of you know that it's form 780 and use it with your clients? Do a lot of people? If you don't, I would consider putting this in the package that you give to your clients, whether it's on the listing side or the buyer side, at your first meeting. I think it's an informative piece that talks about our contract and the things that people should be thinking about. And again, when is the DDF due and payable? The DDF is due immediately when the contract becomes effective. And if the DDF is not delivered with one banking day's written notice from the seller may terminate the contract and seek recovery of the DDF, as well as any earnest money deposit that has been paid or is payable. In addition, the buyer's right to terminate the contract for any reason or no reason at all during the due diligence period does not apply unless the buyer has paid any DDF that has been agreed on. That is a very easy and clear message to buyers when we have such high due diligence rates right now that they can easily see, and it's reminding them again, because I think one of the things we've gotten away from just talking to agents is we're sending things over via DigiSign, SkySlope, DocuSign, whatever system you use digitally, and we're not educating our clients on the provisions within the contract. And so we need to be very clear, because if the real estate commission comes and knocks, or we get a legal complaint, the number one thing they say is, well, can you tell us the communication? How did you advise your client on this? And if we just say we sent it via DigiSign, that's not sufficient education of our clients. Haley, it looks like there might be a question.
So no, there's not a question. Hottie is talking very loudly, it sounds like, in the office beside you, and I'm texting everyone trying to find out how I can have him lower his voice for the next 40 minutes.
Okay.
So that's what's going on.
Okay. Give me 2 seconds and I'll tell him.
Okay.
Oh, thank you. Thank you.
I was just going to say, I just closed his door. But
Okay.
I closed it when you said it, but evidently he's still talking loud.
I know. How do I tell the owner of the company to talk quieter? Thank you, Kim.
Well, I don't think that the door is going to be a great solution, Kim. So if you could take your keys and you could open the door and tell him, because the door is locked.
Yeah. Okay, I'll let him know.
Okay,
Thank
sorry
you.
about that, guys. So as we move through this is basically a very clear, has a lot of questions, and I would pick several of these questions and talk to your buyers and sellers about them, and then make sure that they have read it and maybe even have them sign off on it. Okay, So that is a document that can be found in the forms for North Carolina. We are going to move on to the offer to purchase. And the offer to purchase has several significant changes to it. Here you will note that they are clearly stating manufactured mobile homes will or will not include. So if the property includes a mobile home, do it here. Now, there aren't a ton of mobile homes in our area, but there are enough that we have had 2 or 3 issues recently to where the tags were never retired. And again, a mobile home is personal property until the tags are retired at the DMV. So if you are going to list something that is a manufactured mobile home, you need to make sure that the tags have been released and that you have all of the information. There are multiple ways to find serial numbers on manufactured homes. Some are not the greatest in terms of having to go under the place to look for them on the frame, but if you're going to buy and sell and work with mobile homes, you need to educate yourselves on mobile homes and the processes and some things that can go wrong so that you can alert your clients and you can have a best possible practice of a transaction.
Will you please zoom in on the forms?
Sure, thank you.
Thank you.
When I got up, I forgot to go back. Is that big enough? Okay. So as we are looking at this was a mobile home piece that I just spoke of. And then I think all of us will be excited to see one less checkbox. So by initial earnest money deposit, it says either, and basically they took it out and just said within 5 days of the effective date of this contract. Now that doesn't mean that the seller can't say that I want to see a copy of the earnest money or I want that money to be delivered immediately and require it because it says within 5 days. So be cognizant of that. You don't have to check it. But one thing I have seen, and I want, if admins are listening to this as well, make sure people are checking this stuff, because if you're not checking it, we're not being clear on the contract. And if it's ever up for scrutiny, that's an issue because we weren't being specific.
Tiffany, is there a good place to look for info on mobile homes?
There are a number of resources and places to look. I can share some links later and we can do a follow-up to this and post that or share it maybe in the email and on the real estate agent portal.
I'm sorry, Tiffany, can you go through that for just a second? I had someone at the front desk.
Sure, no problem at all. So if you're an admin, if you're an agent reading this and looking at it, what you need to be cognizant of is you can't just leave all of these checkbox blank.
Oh.
You need to have something checked here. And so even though it's just a minor piece, if someone is scrutinizing this in the future for a lawsuit or the commission, it's going to be a problem if things aren't marked and aren't checked. So your due diligence up front, if you're an agent, if you're an admin, make sure that our agents are checking that. And then this within 5 days is a new piece. It doesn't have to say by effective date or otherwise. So it's nice. We have one less checkbox. And then it again added and wire, because now we're doing electronic transfers and wire transfers, and there's a difference in those. So down here, I'm sorry.
If someone says that they will pay with a personal check, but decides to do a wire transfer or vice versa, and if the money gets paid, do we need to change the checkbox after the fact?
I would make sure that we have in writing that it is changed and that it has been received. And so when we have someone signing off on the due diligence fee received or the earnest money received, we should just acknowledge received by X so that we're clear. So again, the same thing that we saw in the listing agreement piece, we've taken fuel tanks out of this section, which is specified items that will remain with the property. We've made sure inflatable pools, everyone knows that they are not personal, or that they are personal property. And here again, that correction. All of this with the fuel tanks, and in addition, any leased fuel tanks identified in paragraph 7D shall not convey is the same as the listing agreement. It's just making it consistent among documents. Here under loan, North Carolina and South Carolina are different in this regard. And in North Carolina, more and more people are filing complaints saying I should get my due diligence money back because I didn't get my loan approved or my earnest money. Well, they wrote here very clearly, there is no loan or appraisal contingency in this offer to purchase and contract. And then it again reminds you that you need to have sufficient time for the due diligence period and for the loan process to happen if that is of concern to you. So again, fuel tanks is moved here and this lease piece was all put in one place. So again, on the repair and improvement negotiations agreement, they went ahead and changed it to put in big bold letters. And so when they circle things in blue, do things in bold, or do the red, that's to draw attention. And so they want to make sure that the buyer acknowledges and understands the following. Unless the parties agree otherwise, the property is being sold in its current condition. This should be something that you point to and share or educate your client on as they're signing digitally. Remember, just because we're doing it digitally doesn't mean that we're not going over these points with our buyers and with our sellers. And then seller may, but is not required to engage in negotiations for repair improvements to the property. That's an important one with the amounts of due diligence, and who knows where our due diligence will go from today forward, but it's still pretty high. And buyers have been calling and complaining to the Real Estate Commission and to the Realtor Association quite a bit because they weren't clear on this. I think all of our agents are very clear on it and very straightforward, but you want to make sure that you're following everything that you can to protect your client, protect yourself, and protect the firm, of course. So then it's basically reminding everyone that everything must be in writing and signed by all parties. So any verbal agreements or changes to the contract, unless they are in writing and initial and dated or signed by all parties, is not effective. So just think about it. If you're doing a repair agreement and you've gone back and forth via email, but you didn't get any signatures, that doesn't mean you really have a repair agreement unless you have it in writing specifically from the seller or specifically from the buyer.
Tiffany, Chelsea has a question. If an agent uploads an old form that isn't revised, do our admins have to require agents to upload the revised form?
So we had 60 days from July 1st. And so that's not until September. So in September, if we're not getting it on this form, then that is an issue. Now, if the listing agreement or it happened during the 60 days, but they're just putting it up, that doesn't mean they have to change it. That just means that the date signed needs to be congruent with the form date changes and the 60-day notice that we were given to switch over to these forms.
So if it was signed before September 1st, they can keep the form, but if
Yeah.
it's after, then reject. Okay, thank you.
And that's a great question, Chelsea, and thanks for bringing it up, Haley. A reminder, any forms that you have, the reason why we have SkySlope, the reason why we have the checklist is the Real Estate Commission and all require us to have all of our documents to where we can get to them within 3 days. And so if you are getting a buyer agency and you're holding it in your car or in your DocuSign or your DigiSign for 3 weeks or until you get an offer to purchase, that's a problem. And we need to make sure that we're getting our paperwork in well before we actually go to closing, because we see several agents that are repeat offenders that don't put anything into SkySlope until it's actually closed. And we need to work at getting better at doing it more consistently upfront, because the more you do upfront, we're going to catch things that can protect you and protect your clients as well.
When will the new forms be available in SkySlope?
They are already.
Thank you.
And so they're already in SkySlope forms, which is also a DigiSign, and they're in zip forms as well. Okay, so basically the residential property disclosure statement, it's basically now saying that prior to this offer and acknowledges compliance. So if you have not received your property disclosure at the time of offer, then you need to be checking has not received at the time of making the offer. So making versus offer. So if you get it after you've made the offer, you're checking the second box. And then again, the mineral oil and gas the same way. So responsibilities for certain costs, the buyer obligations. What they were trying to do here is put everything regarding owner associations and management companies in one place. So they've moved it to 9A and 9B, and we'll look at that in just a minute, but they're just changing the responsibilities a little bit up so that it's very clear on the homeowners association dues and who pays what relative to receiving that documentation from contract to close. Fuel tanks. This is the identical piece that was in the listing agreement. Now, if you have fuel tanks and you need to disclose those, you need to be very clear on the property disclosures. You need to be very clear in writing prior to client making an offer and you guys negotiating it out so everyone's on the same page. And this is a time when you might want to note that your client just filled the entire tank up and it's good the way your client uses it for 2 years. Don't say it's good for 2 years, good the way your client uses it, because the way your client uses it might be different than how someone else uses it in the home. But sharing the details here and working out the fuel tank piece up front makes a difference as opposed to trying to do it on the back end. So here, owners association fees, this again says going to 9A, so 9A and 9B. This is trying to take everything pertaining to the associations and putting it in one place. Home warranty has moved up a little bit compared to where it was. You'll see it marked through later, but again, it's the same information of no home warranty, buyer may obtain one, seller has obtained one with the pricing. And remember, you need to include sales tax here. The other piece is home warranties typically have limitations on and conditions to coverage. Refer specific questions to the home warranty company. That is one of the reasons why we want you to have either the acceptance or the declination of a home warranty, whether it's Cinch or any home warranty, in your file. That helps you on the E&O side, but it also shows that you actually educated your client on what a home warranty is and what it is not. And again, it's reminding you here that that's an important step on this home warranty piece. Charges by owners association. This is the new 9 that outlines that. And so seller shall pay, and it just reminds you that the seller is completing the property disclosure, sharing information on fees. If they don't know fees, certainly you don't want to put them, or you want to get educated on that by the HOA, but they are paying the fees to transfer and update ownership records. So that's outlined here. And then it's reminding buyers that the charges for providing information based on what the buyer's lender requires is the buyer's responsibility, not the seller's, and any working capital contribution, membership fees, or charges imposed beyond what the seller is required to pay for by law is the buyer's responsibility. And so that's just clearly outlining it in one place as opposed to having it split between the buyer and seller side.
Tiffany, is the home warranty declination form added in zip forms in SkySlope?
It is in SkySlope, I believe, but it's a one pager. You can also find it in the real estate agent portal. And the Cinch one is provided, but any home warranty that you utilize, if you choose another one or you utilize to share more than one home warranty with your client, they all have a declination section. And it's that one page that they can either apply for an application or they can decline it. Okay. So here's where we wiped out the old home warranty section because it was moved up in the contract. And then condition of property, risk of loss. So this condition of property at settlement, the main update here was to say, and the due diligence fee. So if the property is not in substantially the same or better condition at closing as of the date of this offer, reasonable wear and tear accepted, buyer may terminate this contract by written notice delivered to seller, and the due diligence fee and earnest money would be refunded. So this isn't just for your average wear and tear. This, let's say a tornado has come through or there was a flood in the house. That's what this pertains to. So in the past, it had just said the earnest money is returned, but if there is something that comes up and they elect to terminate, their due diligence is also refunded at this time. So that is a material change to our contract.
Miss Tiffany, can I ask a question?
Sure.
So on that part, would we still run into the same situation where if the seller is difficult about giving the money back, that we would have to take them to small claims court or something like that?
Yes, small claims court or otherwise, because with the prices of due diligence, small claims court might not be sufficient.
Got it. Thank you.
Tiffany,
Yeah.
what if there's damage from movers?
Damage from movers, that's typically going to be insurance relative to the movers, and that's going to be the seller's responsibility because they still own the home, and so they would need to be able to remedy that. But if it is wear and tear, like small scratches and some dents in the wall, those are things that can be adjusted, and they're not necessarily going to be a material defect. I mean, if you think about what a mover is going to do to a property, I mean, if a whole wall is busted out because they dropped furniture, all the rail, the staircase, those are things. But if it's a couple of scratches and dents, that's something that needs to be rectified, but it's not necessarily probably going to be something that a judge would think would allow you to back out of the contract. So you need to be smart about that. And if there are questions, reach out to an attorney to clarify what you believe, because what you don't want to do is give legal advice to your client.
Mm.
So breach by the seller, it just again reminds you that the earnest money due diligence goes back, and elect not to terminate and instead treat this contract as remaining in full force and effect and seek the remedy of specific performance. So basically this is giving the buyer the right to sue the seller to say, you contracted, I agreed, no, I want the house. That's what's specific. And so again, the wire fraud warning here. And that is what we've got on the offer to purchase. Are there any questions on the offer to purchase?
Karen has a question about the cinch home warranty. Did you say that we could use the cinch waiver form even if we've presented a different home warranty and the clients decline?
Well, that home warranty should have the waiver in it. I think if you're going to use the cinch home warranty, that you should present the cinch home warranty and have it waived, because you're waiving two different things there, in my opinion. Because one home warranty could offer one thing and that home warranty could offer something else. So you need to have the waiver for the one that you've presented. And the waiver is literally the application form. And there's a little checkbox that says I decline and your client signing it. It's very simple. Okay, now we're going to go through several things. So seller unilateral termination. So termination of contract by notice to buyer from seller. And so
will you please zoom in? Thank you.
Okay. So here, this is basically just updating that written notice from the seller is not required if the buyer doesn't deliver additional earnest money. Now, additional earnest money is hardly ever used, but when it is, the seller doesn't have to provide written notice in order to terminate this if it's not delivered. So here, and just a reminder, oftentimes people come and say, how do I get out of a contract when the buyer hasn't delivered the due diligence money or the earnest money? Well, there is a form to do that the seller demands it within one banking day is how it's set up. And so in certain cases, you might want to just go ahead and include that with the offer to purchase, or say, hey, this is a document that I'd like you to sign off on, or even just include it immediately if there are any reservations or as a standard practice, because then you can use this buyer's failure to timely deliver the due diligence fee or initial earnest money by cash, official bank check, wire transfer, or electronic transfer following written notice from the seller. So if the seller is given written notice at the time of the offer acceptance, then that means within one business day it needs to be there. Certainly in today's environment, if you have people delivering checks via US mail or you're doing it, you need to think again, and primarily because of what happened here in our Ballantyne office. The US Postal Service had issues with their staff and their carriers. And so there was a week they didn't deliver one stitch of mail to our office. We went down to the post office and they basically told us, here are 4 pieces of mail, 3 were junk and 1 was a check. They said, it's such a disaster back there. We have no idea if you have any more mail. So beyond our control, if there's a mail issue, you don't want that to happen to your client, whether it's going to their house, because all of 28277 in Ballantyne wasn't getting mail consistently. They rectified it, but US mail is probably not the best way to send due diligence money. So this is the form, termination of contract by notice to buyer from seller.
Tiffany, what form is it that agents can use in regards to EM and DD request?
I need to go and look. Unfortunately, I never remember the forms by the number. I remember them by the name, and it is basically the demand notice of demand from the seller. And I will find it and I will share it and post it with everybody as well.
Okay.
I need to get better. I never learned them early on as form numbers. I learned them as names. And so I guess I was in the minority on that case. Seller possession after closing agreement. This is basically agreement and an addendum to offer to purchase and contract. And so basically it's just saying such a security deposit. So basically the form does not address important issues typically addressed in a residential lease, such as security deposit. Consideration should be given to using the residential rental contract or other residential lease if that's important to your clients. So the one big change here is termination of term of possession, access by buyer, means of access. So this is seller possession after closing. There's also a buyer possession before closing that we'll look at in a minute. So here, this yellow bolded says buyer shall not access the property during the term without seller's written permission, except in the case of an emergency. Seller shall provide buyer with an entry key to the property at closing. Seller shall deliver all other means of access to the property to the buyer at the conclusion of the term. So just because you bought the house, if you're allowing seller possession after closing, doesn't mean that you're going to have regular access to it. You are entitled to a key, but you are not allowed to enter without the seller's permission unless there's an emergency. And this hadn't happened a whole lot in the past, but in the last 2 years, it's become very prevalent. And there have been a lot of issues relative to key possession and access. So they wanted to just clearly outline that on this document. That's the only other change here. And so let's go to seller's unilateral buyer possession before closing. I might have made that too big. Okay, so again, this talks about security deposit up front and talks about access by seller, means of access. And in reverse, it says seller shall not access the property during the term without buyer's written permission, except in the case of emergency. And seller shall be entitled to retain an entry key to the property, but shall deliver all other means of access to the property buyer on the commencement date. So garage door openers, access codes, all of that. And then here it basically changes where the obligation to maintain the property is in the contract, since the contract changed for the offer to purchase and the numbering. And then the termination of possession. It says if the contract is terminated, then buyer shall immediately vacate the property and return all means of access to the seller. So that's just clarifying that term. It's nothing new, but it's clarification. Okay. So agreement to amend. So you will note amendment numbers. If you have more than one amendment, you start with number 1, then you proceed so that you have a chain of history there, which is a nice update to this agreement to amend. The other piece down here that I really like is this escrow agent. If escrow agent changes in the middle of the transaction and they have the earnest money, here's another way to sign off, or the way you should use now to sign off. And so if there's a successor escrow agent, and the escrow agent named in the contract is hereby authorized and directed by the parties to release the earnest money deposit in the amount of X to the successor escrow agent. This is the successor agent acknowledging they've received the money.
I have a question on this actually, just because I've seen this happen. If you accidentally, if they have like an admin or somebody that puts in the different amount on this, like maybe they typed in the wrong key and did it like 500 instead of 200. Does that change the escrow account from the contract in your opinion, or?
Well, if they made an error there, it needs to be corrected is what should happen. So if the contract says 500 and 500 was delivered and we're moving 500 to the successor.
Could the other agent be like, now it's 500 and my seller wants 500 instead of 200 legally, do you think?
No,
Okay.
because it says parties to release the earnest money deposit. And
Okay,
so
that was my opinion too. I was curious about your professional opinion on that. Just because if that ever happens, because I've already seen it just happen once. I didn't know if anybody else would have that issue. So.
Yeah, in that case, you'd say that was an error and it needs to be corrected. The original amount was X. And so if we don't have more than X, we can't deliver more than X to the successor escrow agent and address it that way. If you're talking about additional earnest money, there is additional earnest money. So right here, the additional earnest money.
Okay, that was my opinion too, but I'm not always right, so.
And Tiffany, Candy has a question regarding clarification on the seller's unilateral termination within 1 business day, with the contract saying the earnest money needs to be delivered within 5 days of the effective date, wouldn't that take away the seller's opportunity to immediately send the form requiring the deposit in 1 day?
It's a due diligence as well. So the due diligence fee, you can, because it's supposed to be delivered at the effective time of the contract. Accept. So you could resend it again. So your due diligence is one piece, and then your earnest money again. And since the seller has already done that, if within the time frame for the earnest money, that money is not delivered, then that should still comply. Any questions other than that on the agreement to amend?
Nothing in the chat.
Okay. Possession, forms change, standard contract. Make sure. Referral agreement. Okay, a lot of us do referrals from agents all over the country, whether they're Remaxed or otherwise. The change to this contract is the assignment piece. And so it says this referral agreement may not be assigned without the written consent of the referring firm, but if assigned by agreement, then the referral agreement shall be binding on the assignee and the assignee's heirs and successors. The big one here, any change in the individual agent shall also require written consent of the referring firm. So if you are a team and your team leader is getting a referral, before it's signed off on, it probably needs to say someone's name and any members of X team, or give specific names. So that's just something to keep aware of based on how they change this referral agreement. Let's see. So everything that I've gone over thus far is all going to be the same if you're doing vacant land, if you're doing new construction. And so be cognizant of that. Let's see. Any specific questions before I move on to a couple of other topics that I'd like to share with you guys prior to us heading out for the day?
Tiffany, what do you think the most significant change to the contracts this year is?
I think
If you had to pick one.
I think it's probably the clarification and making sure that everyone's very clear on the dual agency piece and reorganizing how that was structured in the North Carolina forms. I think there have been a lot of issues regarding dual agency versus designated dual agency. And if you need to brush up on that, make sure you go out and you start looking to do that, because the Real Estate Commission wants to make sure you're sharing the working with real estate agents at first substantial contact, and that you are not just giving them a copy of it, but you're explaining what it is. And in North Carolina, when you're looking at everything, you just got to make sure that you remember that there are duties for dual agency. And the reason why designated was put out there is because of the limitations for dual agency. It gives you more rights if you can do designated agent, but you need to make sure that designated agent makes sense in the situation, and you're not just doing it and overlooking that you told your teammate, or there was a way your teammate could have learned that your seller had some motivation or some confidential information that you're aware of. And in that case, you are not a designated agent, you are a dual agent.
Sorry, Tiffany, can I go back to the referral form, please?
Sure.
So is that referral form, is that one that is required for the agents to fill out for a referral, that referral agreement? Because we never get anything like that.
There are several different ways you can have a referral agreement. This is North Carolina's form that they put out. So the North Carolina Association of Realtors put it out, but there could be some other communication, but this is what North Carolina puts out.
Okay, so, but that's not required necessarily.
It's not necessarily required, but this form is probably the best form to use in terms of outlining the information relative to North Carolina if we ever have a dispute.
Okay.
Any other questions that you guys have on dual agency or anything like this? And this again talks about negotiation strategies. And if you'd like me to post do's and don'ts for dual agency, I can, so that you have it out there and it's easy to look at. That fiduciary responsibility is just something that you need to be clear on and that your client understands. Okay, so let's have some fun. Let's see. So a lot of us are doing a lot more advertising these days because the market is shifting a little bit and you're wanting to get information out there. And so I just want to, these are questions, and shout out what you think the answer is. So is it ethical for a listing agent whose property has gone under contract to put a sold sign on the property and indicate on the internet, social media, website, otherwise, that it has been sold prior to closing?
No.
Guess what?
No.
It says yes, it is ethical. However, listing agents are advised not to advertise a property as sold unless and until it has closed, based on the guidance from the North Carolina Real Estate Commission that the term could potentially mislead the public, which understands the word sold to mean a fully completed transaction. So Bob, you were right. It is ethical, but the Real Estate Commission frowns upon it.
Yeah, I mean, I would think that's a disservice to your seller. If you put sold out there and then the deal falls through, they might get ticked off at you. I don't know. I wouldn't do that.
I completely agree with you. I found these questions and I thought with the advertising, it would be fun if we had time to run through them. May a listing agent advertise that they have sold a property after closing if they did not represent the buyer?
Yes.
That is
Well, yeah.
correct. It says, although brokers may draw a distinction between listing a property and selling a property, the average person probably does not. So the use of the word sold by the listing agent would not be considered misleading in violation of the real estate license law or the code of ethics. Number 3, is it ethical for a buyer agent whose client has put a property under contract to advertise that the property is under contract without the listing agent's permission? Anybody going to answer that one?
No.
No. Okay. I think Hottie's,
No.
I almost heard Hottie say no, but I know he's not talking about this. Standard of Practice 12.4 of the Realtor Code of Ethics prohibits realtors from advertising property without authority. Even if the buyer's agent purpose is to promote the agent's services, it's still advertising the property from an objective point of view. That's in order to avoid a potential complaint that they have violated Article 12. Cooperating agents should obtain permission from the listing agent prior to closing before advertising that the property is under contract. So when you say, I just got this great property under contract for my client, you need to mention that you're the buyer and probably not list what the address is. Can a buyer agent put a sold sign on a property after closing?
No.
Well,
This is after
if
closing.
after closing, if your client, the buyer, says, yeah, I don't mind if you advertise out there,
That's
then sure, why not?
That's right. Yeah, it says yes, provided that the purchaser gives the buyer agent permission to do so, it is permissible under the Code of Ethics and the real estate license law for a buyer's agent who is involved in a transaction that has closed to claim that they sold the property and put a sold sign on the property without having to get approval from the listing agent.
Yeah.
Okay. So there's also a section there. Let's go to 6 and we'll talk about that in a second. So may a realtor advertise property on her website or social media that her buyer client have purchased without the consent of the firms that listed the property or without including the listing firm's name?
No.
Oh.
So on 6, it says yes. Neither the real estate license law nor the Code of Ethics obligates a buyer agent to obtain a listing firm's consent in order to advertise the completed sales transaction in which she participated or to mention any of the listing firm's names. And so that is after the fact. So on 6, may a realtor advertise properties on her website without the consent. It says have purchased. And so that's the difference there. Number 7. If a realtor changes firms, may he continue to display the properties he helped sell while he was affiliated with his old firm on his website or social media?
Yes. Yes.
Yes, you're right. It says, provided that viewers would understand that some of the sales had occurred while the agent was affiliated with a different firm. And then finally, number 8, may a realtor include another firm's listing in her print or social media advertising without the other firm's consent, so long as the other firm is identified?
No.
No is correct. While it wouldn't violate the Real Estate Commission's advertising rule, advertising another firm's listing without authority is a violation of the Realtor Code of Ethics. Even though the other firm and its client might not object to such advertising, the lack of objection cannot be assumed. So, how did you guys do?
Well,
Okay. Is there anything else that you guys have questions on?
Yes, Danielle actually had a question about the referrals.
Okay.
When you're on the Remax portal for a referral and click give referral, is that binding, or is it the point of that just to start the process and then later do the correct form?
I think it's probably doing the form, but it's giving access there. But I would say if you're going to give access there, that you should look at that as something that's going to be binding, because you're doing it online and you're agreeing online, but you do need to have something that you can put in your file.
And that was the last question I saw in the chat. Does anyone have any other questions for Tiffany? All righty.
Well, again, if anyone has any questions on any of the forms that are not used as often that you come across, please don't hesitate to reach out to me and we can work on making sure you have the proper answer and the details. And I'll just caution everyone, if you're not sure about something, ask, educate yourself. Whether you contact your broker in charge, you can contact me at any time, or I got this at the North Carolina Association of Realtors. I don't think you can see it as much. Actually, it's a support hotline. So the legal hotline, the tech hotline, and zip forms are all available. So if you need help and you need resources, check the real estate agent portal, talk to your broker in charge, ask your admin for assistance. But remember, your admin is not your broker in charge, so they cannot answer questions regarding real estate practice. And then finally, make sure that you all are just doing your best for your clients every day, which I know you are, and pat yourselves on the back, because you guys sell more real estate than anyone else in the world. And there's a reason why you're the best. So thanks for today. And again, any questions, reach out.